Hello everyone. Today we are going to start Indian Penal Code 1860, and the first topic of your syllabus is nature of crime and the criminal law. First of all you must understand that what we call Indian Penal Code, it is the law, it is an act, and it is a code which contains all types of crime in it. It is the law under which approximately entire crime has been embedded by the Parliament. Of course, in the year 1860, it was passed. The question is why it is called Indian Penal Code. You must understand it is called Indian because it is applicable to India. At that time, the British government used to pass the law, and therefore they were used to pass the law for their colonies, and they were ruling to India, and therefore this particular code is called Indian penal. Basically we contain the penalty, so therefore penalty and sanction and also imprisonment. So the law which contains penalty is called penal or imprisonment. Now the question is what we call code. Why Indian Penal Code is not called Indian Penal Act? Why it is Indian Penal Code? The answer is whatever the law were available at that point of time, all were contained in the Indian Penal Code itself, whether it is a crime against women, a crimes against society, a crime against military, a crime against political scenario, crime against quine, crime against human body, crime against sexual offenses, or even a crime against property. So whatever the crimes were available at that point of time, all were included in the Indian Penal Code. So basically the code is called entire thing on that particular subject matter. So certainly a question may come in your mind that then what is Domestic Violence Act, National Security Act, TADA, Makoka, and similarly there are many criminal laws which are not included in the Indian Penal Code. Why they are separated? The answer is all, even Domestic Violence Act, National Security Act, TADA, Makoka, all are liable to be included or qualified to be included under the Indian Penal Code. Since every day facing new crime, and therefore if we will include every new crime in the Indian Penal Code, then it will become a very lengthy document, and every month there would be an amendment in the parliament, and now this particular code will become a west document. Nobody would be going to read it, and therefore we are not including every crime in the Indian Penal Code. Rather, we are enacting a separate law for the particular subject matter, or we can say that a special law for that particular subject matter. For example, Domestic Violence Act that deals exclusively with the domestic violence and nothing else, like Sati Prohibition Act that exclusively deals with the Sati Prohibition, or Child Marriage Prohibition Act. So there are many special laws which are enacted by the Parliament to deal with the exclusive subject matter. Now I think you have understood that what we call code. Code is something which includes entire thing on that particular subject matter. Similarly, Civil Procedure Code, criminal procedure. So these all are containing a particular subject matter. For example, criminal procedure code. So whatever the procedure are applicable to our nation, to entire country, that all will be governed by the Code of Criminal Procedure 1973, or in case of civil matters, the Civil Procedure Code 1908. Similarly, there was a proposal to pass Hindu Code Bill, but at that point of time it was not possible to pass, and therefore separate acts, four separate acts were passed by the Parliament. For example, Hindu Marriage Act, Minority and Guardianship Act, Hindu Succession Acts. So these were the acts which are passed. If these acts were enactment, then it might have called as Hindu Code 1956. Similarly, there is proposal to pass Uniform Civil Code. Why it is called Uniform Civil Code? The reason is it contains the law relating to personal laws of all the religion. So therefore, all the religion are contained or been kept at one place, and therefore it is called code, Uniform Civil Code. Now, come to the point that criminal law can be divided into three parts: substantive law, procedural law, and adjective law. The point is what we call substantive law. Substantive laws are those laws under which rights and duties are being defined legislature. For example, the Indian Contract Act, Partnership Act, Sales of Goods Act, Copyright Act, Patent Act. There are various acts which defines the rights and duties of the parties, and therefore it is called substantive law. Similarly, Indian Penal Code is a substantive law because it defines the crime and also contains the punishments. That means what would be the rights of the person who are living in the society, and what would be the duties of the criminals who are committing crime against the society, state to how to deal with these criminals. That all are contained in an Indian Penal Code, and therefore it is called a substantive law. Now, the point number second, that is procedural law. The question is what we call procedural law. The procedural laws are those laws which contain the, for example, civil procedure code and criminal procedure code. So basically we are dealing with the criminal procedure, we are dealing with the criminal law. So therefore in criminal procedure code 1973, the law relating to criminal procedure are contained. So if anyone committing a crime in the society, then his case shall be dealt under the criminal procedure. How the summon will be issued, how warrant will be issued, and how the police will arrest the person, how he will be produced before the court of law, how judge will try the person, how he will be of the evidences, and how the person will be convicted, and up to what extent or what would be the quantum of punishment that the quantum of punishment are contained in IPC, but how the procedure would be followed are given under the Code of Criminal Procedure 1973. Again, the question is what we call adjective law. Although sometimes we are keeping procedural and adjective laws into one footing or at one place, but for the sake of convenience, we may differentiate between procedural and adjective law. There are some laws which contains the rights and duties as well as procedure. So those laws are called adjective law. For example, Indian Evidence Act, which contains the substantive law. For example, the doctrine of estoppel, the doctrine of conclusive proof, the doctrine of paramount law. So there are various substantive the various substantive doctrines are contained in the Indian Evidence Act, as well as is contained the procedure that how evidence would be governed, how evidence would be produced before the court of law. So therefore, we are keeping law of evidence in the category of adjective. Now, come to the point, nature of crime and the criminal law. As you know, there are number of branches of law. civil law, criminal law, personal law, company laws. There are many branches of law. Law is the samudra. The branch which touches the concern of a human being in his day-to-day life is the criminal law, because every day you are seeing, whether on the road, whether in your home, or whether in your neighborhood, that every day there are certain happening, there are certain offenses are being committed by the criminals. Or even on the news, whenever you are watching TV or news channel, then you will find the crime are being committed by the criminals. So this is the law which touches the day-to-day life of the human being. It is true that the crime and criminal both looked upon the greatest hatred by all the sections of the society. The reason is that either it is crime or criminal, both are affecting the society very badly, and every human being are being sensed or being fearful by the crime and the criminal both. Whereas Mahatma Gandhi says, hate the crime and not the criminals. It is a philosophical thing, but the society hates both the crime as well as the criminal. It is also true that the study and the research of law of crime has always been one of the attractive branches of the criminal jurisprudence since early year of human civilization, because it is the law which touches the human concern. Whenever people are organized themselves into groups or association, there is need for some sort of regulation to regulate the human behavior or the behavior of the members in the society. And therefore, when we are regulating the behavior of the human being, then we need some sort of rules and and if someone is violating those rules or regulation, then definitely there would be some sanction, there should be some pain of punishment. Otherwise everybody would frequently violate the law. So therefore there is need of some sort of regulation, because once the people are organized in some groups, or they are assembling at one place in large number, so therefore at that point of time there is some sort of regulation. For example, section 144 of the criminal procedure code 1973, that contains the law to disperse the crowd, and it is being issued by the SDM or DM of the particular district. In every organized society, certain acts are forbidden on the pain of punishment. What does it? That if someone is violating the law made by the parliament or is it legislature or the highest lawmaking body, then in that point of time, if there is any violation of the law that has already been forbidden by the law, then definitely there would be some pain of punishment. Let us take an example. Suppose one person injured another. For example, A injured B. Now B could be adequately compensated by money value. What does it mean? A may give some amount to B. Here, wrongdoer is required to pay damages to A, that you might have studied under the law of torts, but in certain cases, in addition to damages, the state impose certain penalties with the object to preserve the peace in the society. If suppose one person is committing crime and he is paying damages, at that point of time he will continue to commit crime, the grievous crime, the crime which affects at large, for example the murder, the dacoity, rape. At that point of time he would commit the crime and he will pay the damages. So it is the duty of the state to impose certain penalties. Penalty means the sanction, the imprisonment, or even the death penalty to preserve the peace in the society. Come to the point, the definition of crime. There are many attempts has been made to define the crime into a precise manner, but all failed. The reason is they are failed to identify what acts or omission amount to crime. That means what kind of acts should be called as crime, as well as what kind of omissions should be declared as crime, and what kind of acts should not be declared as crime, and they can only be said as it is a forbidden act, or it is an act which is civil in nature. So it is very difficult to define the crime. Now certainly a question may come in your mind that of course an act is crime, then how omission can amount to crime? Let me give you an example. Someone committing an offense of murder by stabbing to other person. For example, A is stabbing B by stabbing him. Okay, it is called stabbing is called an act. As the husband is not providing food to his wife, it is his duty to provide food, but he is not providing food, and the wife died due to starvation. She died due to hunger. At that point of time, it is called omission, and acts and omission are kept at the same footing, on equal footing, even whether it is omission or whether it is act, both are amount to an act committed by the wrongdoer. For example, the jailer, he is having duty to provide food to the prisoners. If he is not providing food to the prisoner and the prisoner died due to starvation, at that point of time it is called omission, and therefore the jailer will be responsible for the offense of murder of the prisoners. So why it is very difficult to identify the acts or omission, which acts or omission are amount to crime? Perhaps this is because of changing notion about the crime from time to time and place to place. At one point of time it may be a crime, and again at different point of time it may not be a crime. For example, adultery, before 2019 it was a crime as contained in the Indian Penal Code, but now it has been declared as unconstitutional by the Supreme Court of India, and it is no more a crime. Suicide was a crime, but now it is not a crime. Similarly, the definition of crime are changing from place to place. At one place be a crime, at other place is it may not be a crime. For example, adultery was a crime in India, but it was not a crime in England. You must also keep in your mind that the very definition of crime or the concept of crime varies not only according to values of the particular group or the society, and also it is not only varies according to its ideas, its ideals, its faiths, its religious belief, custom, and tradition, but also it varies according to the forms of the government, political structure, the economic structure of the society, and there are number of other factors which governs the country. They also change the definition and also the concept of crime. For example, indirectly the RSS is ruling over the country through its political group called BJP. So in that sense, if someone is carrying a cow, and if a group of people are killing those person, then it is not considered to be crime, rather it is considered to be a pious act. So it is a changing notion of concept of crime, because it is not considered to be crime by a section of the society, of course not large section of the society, but a group of particular individuals, those are considering to be not a crime. Therefore the problem is as to what acts should be forbidden or what acts should be selected for punishment by the society or the state, or in other words, what should be declared as crime. It is a very difficult question, it is a very complex task on the part of the parliament or on the part of the state, that which one should be selected for the punishment and selected for merely a penalty, and which act should be exempted from the purview of the crime. Come to the point that is called definition of crime. According to Terence Morris, crime is what the society says. Whatever the society is saying that it is a crime, it is a forbidden act, then it can be declared as crime, because it is the duty of the parliament to declare that particular act as crime, because the society wants that it should be declared as crime by establishing that an act is violation of criminal law. If it is in violation of criminal law, then definitely it would be termed as crime, and therefore the person would be punished for the offense. Now the question is, what we call the crime and what we call the offense. You must distinguish between these two terms, the crime and the offense. These are two distinct terms, both are not similar, both are not equal. The crime is something which society thinks that it is against our moral values, and also the crime includes the term the offense, whereas offense is something which has been defined under the statute. If the statute is defining something that it is a crime, it is an offense, then it is called an offense. So the crime is having very wider connotation, and whereas the offense is having very narrower connotation, because the offense is something which must be defined, then only the person will be punished. Otherwise, if he is committing crime but if it is not been defined under the law, and therefore at that point of time the person would not be punished. For example, Dowry Prohibition Act came into existence. Before that it was not a crime, because society were happily accepting it. Even today, society is not considering dowry as crime, even though it has been defined as an offense under Dowry Prohibition Act, but it is not a crime in the eyes of the society. So you must keep in your mind that without law there can be no crime at all. I repeat, without law there can be no crime at all, and it is called ex post facto laws. Ex post facto laws as given under Article 20 Clause 1 of the Indian Constitution. So for punishing an individual, the crime must be defined. For example, the offense of theft is not been defined in the law. Suppose, although it has been defined under Section 378 of the Indian Penal Code, but suppose the theft has not been defined under the law, and if someone is committing the offense of theft, then he cannot be punished, even though the society is considering it to be a wrong against the society, but he cannot be punished for that particular act, because it has not been defined, or in other way we can call it is not an offense under the law. Although it may be a crime, but it cannot be called an offense because it has not been defined. So for punishing particular individual, the crime must be defined, and therefore it is called ex post facto laws. And also you would study under Article 20 clause 1 that there would not be greater punishment than defined. That is different aspect you would study under the Indian Constitution. Also, you must keep in your mind that concept of crime has always been dependent on public opinion of the time. What does it mean? If the public thinks that it is a crime, then it would be converted into crime by the parliament. We also say that criminal law is the mirror of public opinion. Whatever the public opinion is at that point of time, at that particular time, then it is called as criminal law. For example, in Delhi gang rape case, it is also called Nirbhaya case of 2012, December 2012. At that point of time, there were very hue and cry throughout the country, and the public were on road, and they demanded to amend the law relating to rape in India, the law relating to rape in the Indian Penal Code. And therefore, Justice Verma Committee has been made by the Government of India. Justice Verma Committee, he was retired Justice of the Supreme Court of India. He was assigned a task to propose an amendment in the relating to rape or the crime against women, and therefore the government of India has given the time of 30 days to propose an amendment, and he submitted his report on 27th day from the date of assignment of task. And on his proposal, Criminal Law Amendment Act 2013 came into existence on 3rd of February 2013. Dear students, in order to know the nature of crime, we must first of all know that what is the law. Because two questions, crime and the law, are closely associated with each other. So for that, we must go through the definition given by the John Austin, that law is the set of rules set by men as political superior to the men as political inferior. That means those who are sovereign, who is the sovereign or setting the rules for the men who are political inferior. That means the Janta, the public. Or he also says law is the command of sovereign to the political inferior, which is backed by sanction. What does it mean? That there is command by the sovereign as political superior for the political inferior. If he is violating those commands, then at that point of time there would be sanction by the political superior for the political inferior. We can set this particular principle into our scenario. For example, the legislature, the parliament or a state legislature passing a law for the society, and they are setting some rules as political superior or as the sovereign. And if the society is violating, if any individual of the society is violating those rules or those norms as set by the parliament, then definitely there would be sanction, there would be punishment, there would be imprisonment by the court of law. So the disobedience of law termed as crime, but disobedience of all laws is not a crime. You must keep in mind, I repeat, that disobedience of all laws is not a crime. For example, breach of law of contract is rather the person would be paying the damages. Similarly, breach of personal laws is not a crime. Breach of civil law is also not a crime. Although there is a Talake Biddat Act of 2019 where the pronouncing triple talaq is considered to be a crime or declared by the parliament as crime, although it is in violation of fundamental jurisprudence of criminal law, that it is a civil act, it is civil in nature, but it has been declared as crime by the parliaments. So unless breach law is not declared by some statute, some act is crime, until then it cannot be punished. The person cannot be punished for those acts. So first the law must be defined, then only person would be punished. And also breach of all laws is not a crime. Crime and moral sentiments. For a common man, crime are those acts which leads to serious condemnation in the society. A common man is considering to be a particular act a crime which leads to a serious condemnation by the society. As I already told you, if the society is not considering to be a serious condemnation, then it cannot, then society is not considering it to be a crime. For example, the dowry. Dowry, although it is an offense, but it is not considered to be a crime by the society because it has no serious condemnation in the society. So, crime is both forbidden by law and against the moral sentiments of the society. It is forbidden by law because it is defined under the law that if you are doing some certain acts, then definitely there would be a pain of punishment. For example, the murder, it has been defined under section 300 of the Indian Penal Code, and therefore if someone is committing an offense of murder, then he would be punished under section 302 of the Indian Penal Code. So it is forbidden by law, and also it is against the moral sentiments of the society. Similarly, the robbery, the dacoity, the theft, the rape, these are the certain crimes which are forbidden by the law, and also it is against the moral sentiments of the society, and therefore it is called crime. The problem is what we call moral values. Actually, moral values change from place to place, and also it changes from time to time, society to society, and also from country to country. It varies. What may be moral in the state of Kerala that may not be moral in the Delhi or in Mumbai or in metropolitan cities. For example, adultery. Although adultery has been declared as unconstitutional by the Supreme Court of India, the crime of adultery has been declared unconstitutional by the Supreme Court of India, but it is against the moral values of the society, Indian society. I talk about the Indian society. Although it was not against the moral values of the British societies, but now it has been declared unconstitutional, still it is against the moral values of the Indian society. Similarly, Sati Prohibition Act was passed by the parliament. Earlier it was not a crime, but now it is crime, but still it is not against the moral values. Sati is not against the moral values. Now the polygamy. Under Mohammedan law and Christian law, it is not a prohibition. A person may for number of marriages, and therefore in Mohammedan law it is not against the moral values of the society. Similarly, among the Hindus before 1956, polygamy was allowed after passing of Hindu Marriage Act 1956. The polygamy was prohibited. Similarly, unnatural offences that was declared unconstitutional in the year 2018 by the Supreme Court of India, but it was against the moral values. Although it has been declared unconstitutional, but still it is against the moral values of the Indian society. Suicide. Suicide was considered to be a crime, suicide was considered to be an offense, but now it is no more an offense. Suicide is no attempt to suicide. Actually, basically, it is a crime. If it is a crime is successful, then he shall not be punished. If someone is unsuccessful or he was at the stage of attempt, then he shall be punished. But now it is no more a crime by the Mental Health Care Act 2017. So Mental Health Care Act was passed in the year 2017. By virtue of section 115, it has been decriminalized by the parliament. So suicide is no more a crime. Thank you very much.